Grateful.
Yes, Mr. Upton.
May it please, Your Lordship.
Lord, if your lordship gives me 5 minutes before my learned friend starts,
Yes.
possibly the controversy can be narrowed down. Lord, the learned AG and my lord submissions are going to be that the view of Justice S.C. Agrawal is the correct view. Lord, I had viral fever for 2-3 days back, so that I don't spread. So that's
You're feeling better now?
And that doesn't deter the strength of his submission.
grateful.
Yes, Mr. Upton.
May it please, Your Lordship.
Lord, if your lordship gives me 5 minutes before my learned friend starts,
Yes.
possibly the controversy can be narrowed down. Lord, the learned AG and my lord submissions are going to be that the view of Justice S.C. Agrawal is the correct view. Lord, there are two aspects to it. Both majority and minority go into two aspects: immunity, etc., under Article 105, and PC Act when the offense is complete. Lord, I have read the judgment, my lord, fully. Irrespective of the 105, the contours of immunity, privileges, etc., both come to the conclusion that the offense is complete the moment there is an offer for bribe and you accept the bribe. That was the statutory position prior to the amendment of the PC Act in 2017, and even thereafter. Narasimha Rao judgment is prior to 2017. It was amended thereafter in 2017. That is the position. The offense of bribery is complete when I offer money to a member of parliament or a member of assembly, he accepts. Then whether he performs the part of his bargain inside the house or not has nothing to do with the criminality attached. So essentially, my lord, in my respectful submission, it's more a question of interpretation of PCI rather than, my lord, 105.
But the further question as to whether there is immunity still survives.
Whether it extends or not.
No, my lord, if
Whether, if, because our court has held, the majority held, that irrespective of the criminality, immunity attaches. And the only exception they made was to a person who does not fulfill their part of the bargain, because they said that the words used in 105 are, it's in the past tense.
yes,
Vote given or speech made. So they said if there's no vote cast or no speech made, though the bribe was taken, then there is no immunity. That's why Mr. Ajit Singh had to stand the prosecution.
correct. But my lord, my respectful
So
submission.
we'll have to ultimately deal with the issue of immunity as well, as to whether they are right on the broader immunity. And what we have to do is this: since we are sitting as a bench of 7, we need not look at in all the circumstances what is the extent of the immunity enjoyed. We have to decide a very narrow issue: can immunity attach when there is an element of criminality?
That's
Correct. But only, my lord, it's ultimately my lord's call. But suppose, my lord, the performance of the part of the bargain by the elected member is not relevant. Whether he voted or he did not vote, whether he spoke or did not speak, it may not have relevance because the offense is committed outside the house. Then the privilege, my lord, question may not arise.
No, but then actually you are right. But then we will have to say that the immunity does not attach. That's what you are also saying.
Correct, my lord, correct.
Ah.
But on interpretation
so we
of
cannot then say that we don't have to go into whether there is immunity or otherwise. We'll have to say if the offense is committed outside, as you said,
yes,
then there's no question of the immunity attaching under 105.
Correct. Therefore,
immunity can never attach where there's an element of criminality.
therefore, the respectful submission is the interpretation of PCA may be more relevant than 105.
That's how we approach it. Actually, you're right. But it's good now. The controversy really narrows down because you're also of the view that the view of Justice Agarwal,
Yeah, yes, ma'am.
speaking for two judges, is a more correct view because
Yes,
there
ma'am.
was-
Someone
Justice,
takes a bribe outside
Justice
the house,
Anand,
my lord, and claim immunity.
Justice Bharucha and Justice Anand on the other side, and Justice Ray agreed with them on this issue of immunity, and that's how it became a majority of 3.
Well, that takes us to a narrow question of a nexus.
But we will write even on the question of immunity. So there is now a fair degree of commonality and understanding. We'd like you to assist the court because I mean all your research and your the vision of lawyers on both sides will assist us to frame it properly ultimately.
But the only worry, and I'll be very candid, because of facts of bribery, etc. 105 may not be revisited, except in case of bribery.
Yes, yes.
The Raja Rampal line of judgments, etc. What are the contours?
Solicitor, you are entirely right, because we should not be entering on issues which don't strictly arise before us, because the law has evolved in our country by very interstitial steps. There has been some relaxation from the UP case, then finally Raja Rampal, then we have followed Raja Rampal. So we'll not revisit that, though we are in a bench of 7, except on the issue of bribery. What arises?
That's all. Right. Because in that case, the submission would be that inside the house, the legislature would have as much independence as it has, as much like any other organ of the state.
Absolutely, there's no doubt about it. The whole purpose was to encourage free speech, have an unrestrained dialogue in Parliament and in the state legislatures. And that we must preserve. It's a very important part of our nation, the legislature, both in the union and in the states.
And, we are not to be heard saying that bribery is condonable.
No.
May I start, Millards?
Yes.
With a request and a promise, Millards. The request is that if the ambient temperature is increased a little bit, Millards, because we are freezing, we promise to be cool in our arguments, Millards.
Yes, I'll just tell them.
Lordship, please. Millards, only for the benefit of Justice Narasimha and Justice Sanjay Kumar, who were not there on the previous occasion, just a few lines of introduction and then I get straight into the matter, Millards. This, Millards, is a regular criminal appeal arising out of a judgment of the Jharkhand High Court declining to quash prosecution against the appellant, who is being prosecuted under, Millards, relevant provisions of the Prevention of Corruption Act and the Indian Penal Code for the alleged offense of taking a bribe to vote in a Rajya Sabha election. The appellant was at the relevant time a sitting MLA of Jharkhand. She's alleged to have taken a bribe from an independent candidate to vote for him rather than for her party candidate. But in the event, the vote was actually for her party candidate, because that comes out in the open voting. Then there were complaints that election was countermanded. There was a fresh election. And again, she voted for her party candidate, etc. But she was sought to be prosecuted on this allegation. That is how, Millards, the matter arises. The Lordships are, of course, not concerned with the merits of the appeal just now. I have, in my written submission, Millards, Volume 1, just touched upon the merits only to indicate the nature of the controversy. And we contend, Millards, that we have a strong case on merits. The order granting bail in 2014 passes adverse observations against the CBI, Millards, and the CBI has not appealed against the order granting bail. So apart from other things, Millards, apart from immunity, I have a strong case on merits, but of course, your Lordships are not concerned with that, Millards. Now, Millards, can I first place the language of the articles, then come to the order of reference, and then come straight to my submissions, Millards. Constitution redaction. I will read only 105 Millards, not corresponding 194, because they are pari materia, Millards. So all my lords have got 105. 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. So that is, my lords, subject to the provisions of the Constitution. But, my lords, 1052, no member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament. Kindly note here the word Parliament, because I'm going to draw a distinction with the second part, my lords, of this provision, or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either House of Parliament of any report, paper, votes, or proceedings. So the same clause, my lords, of Article 1052 uses Parliament in two different contexts, my lords. One, Parliament, the other is House of Parliament, and I am going to make a submission on that, my lords, in due course. 3, in other respects, the powers, privileges, and immunities of each House of Parliament and of the members and the committees of each House shall be such as may from time to time be defined by Parliament by law, and until so defined shall be those of that House and its members and committees immediately before the coming into force of Section 15 of the Constitution, 44th Amendment Act, 1978. The provisions of clauses 1, 2, and 3 shall apply in relation to persons by virtue of this Constitution, who by virtue of this Constitution have the right to speak in and otherwise take part in the proceedings of a House of Parliament or any committee thereof as they apply in relation to members of Parliament. Therefore, my learned friend, the Attorney General, addresses Parliament, my lords, he will also have the same immunity. Now, my lords, may I take my lords straight to the order of reference dated 20th of September. It is, my lords, a detailed order of 16 pages. But for the present purpose, my lords, it's enough for me, my lords. This will be at page 3 of volume 3.
Volume.
Page 3, volume 3, my lords. I'll take my lords straight to page 15, my lords, because the first part, my lords, sets out the nature of the controversy, how the reference
These are the
was made.
pleadings, right?
Lordship, please, lords. Has pleadings and orders, my lords.
28th of September.
20th, 20, my lords.
One second.
Well, have been able to locate it. Volume. Para 24. I'll take my lord straight to para 24 at page 15. We are inclined, may I read notes? If all my lords have got minutes. My Lord the Chief Justice notes.
Yeah.
We are inclined to agree with the submission of the amicus curiae and Mr. Gopal Shankar Narayanan, Senior Counsel, that the view which has been expressed in the decision of the majority in PV Narasimha Rao requires to be reconsidered by a larger bench. Our reasons prima facie for doing so are formulated below. 1. Firstly, the interpretation of Article 1052 and the corresponding provisions of 194(2) of the Constitution must be guided by the text, context, and the object and purpose underlying the provision. The fundamental purpose and object underlying Article 1052 of the Constitution is that members of Parliament, or as the case may be, of the state legislatures, must be free to express their views on the floor of the House or to cast their votes either in the House or as members of the committees of the House without fear of consequences. While Article 19(1)(a) of the Constitution recognizes the individual right to the freedom of speech and expression, Article 1052 institutionalizes that right by recognizing the importance of the members of the legislature having the freedom to express themselves and to cast their ballots without fear of reprisal or consequences. In other words, the object of Article 1052 and or Article 194(2) does not prima facie appear to be to render immunity from the launch of criminal proceedings for a violation of the criminal law which may arise independently of the exercise of the rights and duties as a member of parliament or of the legislature of a state. Secondly, in the course of the judgment in PV Narasimha Rao, Justice S.C. Agarwal noted a serious anomaly. If the construction in support of immunity under Article 1052 for a bribe taker were to be accepted, a member would enjoy immunity from prosecution for such a charge if the member accepts the bribe for speaking or giving their vote in parliament in a particular manner and in fact speaks or gives a vote in parliament in that manner. On the other hand, no immunity would attach and the member of the legislature would be liable to be prosecuted on a charge of bribery if they accept the bribe for not speaking or for not giving their vote on a matter under consideration before the House, but they act to the contrary. This anomaly, just as Agarwal observed, would be avoided if the words in respect of in Article 1052 are construed to mean arising out of. I'm going to contest that, Bruce. In other words, in such a case, the immunity would be available only if the speech that has been made or the vote that has been given is an essential or integral part for the cause of action for the proceedings giving rise to the law. And thirdly, the judgment of Justice S.C. Agarwal has specifically dwelt on the question as to when the offense of bribery would be complete. The judgment notes that the offense is complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the illegal promise by the receiver. The receiver of the bribe would be treated to have committed the offense even when he fails to perform the bargain underlying the tender and acceptance of the bribe. This aspect bearing on the constituent elements of the offense of bribe finds elaboration in the judgment of Justice Agarwal, but is not dealt with in the judgment of the majority. I'm going to submit, Millets, that the fact that the majority did not specifically say when the offense of bribery is complete does not make a difference to the correctness of that conclusion, because Millets, the majority could not have thought otherwise. The offense of bribery was, after all, Millets, in criminal law complete earlier. But that, in my respectful submission, would not have a bearing on the question. We have already noted that efforts in seeking a review of the judgment in Narasimha Rao, and the rest I need not read much. Your Lordships only noted that previous attempts failed, but Your Lordships have considered it necessary to refer for the following reasons. Now, I have made a detailed written submission, which is volume 1, but from that written submission, only for the convenience of the court minutes, I am handing up 6 bullet points minutes.
Upload because so that all the members of the bar in the court can also follow it.
Take me straight here to Keshav Mills.
Yes, Mr.
Lord,
Ramji. Overruling.
Overruling the long settled law in Narasimha Rao, in the Narasimha Rao case, is unwarranted, according to the tests laid down by this honorable court for itself on the question of overturning judicial precedents. This is going to be my starting point, minutes, because this is the reference being made, minutes, and the reason for emphasizing this at the outset is to highlight the caution which the court has given to itself in the matter of overruling precedents. So I hope, Millards, by placing these judgments at the outset, Your Lordship's decision to reconsider would be guided by these tests which have already been laid down. That's the purpose of citing these cases, Millards, at the outset. So the first, Millards, is an early decision, Keshav Mills, Millards, which was an income tax case. And
we
that,
just read-
Millards-
can we just actually read through your 6 points so that then we can go to
Very
the,
well.
then your judgments again.
Lordship, please. Two, the concept of constitutional privileges and immunities is not in derogation of the rule of law, but is a distinct pillar in the constitutional edifice. This submission is made, Millards, in the context of Justice Agarwal's judgment and something which has been highlighted by those who are questioning the correctness of the majority, that this is the antithesis of the rule of law. My submission is going to be that no, it is perfectly consistent with the rule of law. The rule of law postulates constitutionalism, and one of the pillars of constitutionalism historically, traditionally, has been a regime of immunities and privileges as well. And so there is no inconsistency with the rule of law. Three, the so-called anomaly in the majority view in Narasimha Rao flows from the plain language of Articles 1052 and 194(2), and to whittle down their protective scope to adhere to what is seemingly logical, fair, or reasonable would be constitutionally unjustified. Four, the dissenting judgment in Narasimha Rao has erred in reading in respect of as arising out of. Such a reading is not warranted by either the plain language or intent of the provision. Five, the fact that the offense of bribery in criminal law is complete when the bribe is given and is not dependent on the performance of the promised favor is of no consequence to the constitutional immunity under Articles 1052, 194(2). Once a speech is made or a vote is given, the nexus in respect of is fulfilled. And Millards, finally, this is in the context, Millards, of the submission that in any case, voting for a Rajya Sabha election is not entitled to this immunity because it is not a vote. It is not a legislative vote. That is the submission. And that is where the distinction which I had drawn, Millards, I will, Millards, highlight that no, it doesn't have to be a legislative proceeding in the sense of voting in a house of the legislature. It is part of a legislator's function as a legislator. Article 80 of the Constitution constitutes the electoral college for the Rajya Sabha. An MLA is constitutionally made part of that electoral college. So one of the essential duties of an MLA is to vote for a Rajya Sabha election. So this voting, though not on the floor of the house, but in the lobby of the house, is nevertheless a vote in the legislature. And so if there is a protection for a vote on a bill in the house, equally the protection should apply to a constitutionally mandated role of an MLA to vote in a Rajya Sabha election. Lordship,
Whose case is it that it doesn't extend?
the Attorney General's case, Millards, one of their reasons for saying that this reference is not necessary, they contended before the 5-judge bench also, was that in any case, Narasimha Rao will not apply. Lordship, please, Millards. Now, Millards, can I take my lords straight to my written submission, volume 1, page 12, Millards, the relevant portion starts. Under the subheading D, Millards, whether the concept of parliament.
Just 1 second. How long would you take? About an hour or so today?
Well, it will go a little beyond lunch minutes. I can't say it will be over in an hour minutes. It will go, that's my estimate minutes.
A little beyond lunch, just so that we can have an assessment of everybody. We are, of course, continuing the hearing. Mr. Patwalia, the mic is, how long will it take?
Depending on how much of the judgment is read by my learned friend, about an hour, hour and a half.
Actually, what we could do is we can hear Mr. Patwalia ideally after the others have argued. Wouldn't that be better? Because, we then have a complete unfolding of the case by everyone. And then as a Amicus, you can then wrap it up for us and.
After him, Lord, just to give the counter view.
Because Mr. Ramachandran is known against all of us.
Yes.
Right,
He is effectively going to be taking the burden of saying Narasimha Rao is right.
right. All of you are on this side. So according to once Mr. Patwalia concludes, then of course we like the attorney to give us his vision because, that's it's a constitutional interpretation.
Maybe we can do a little bit more after the attorney also. So that
I-
the amicus then
If
to
the
the-
amicus and we
Would-
can complete.
I also,
I'm starting from here. Why?
Can it be like this
Because the link will go in any case to us once I show.
that if I have the benefit of the amicus assistant,
Then you're,
probably I can refine my thoughts further.
exactly. All right, then that's perfect. Then we'll hear Mr. Patwalia right after Mr. Ramchandran. And then,
we will be supporting the amicus.
and then you can see what else is remaining. Of course, then the attorney can.
Whatever remains, the attorney minus the learned SU.
Of course, of course. We'll see, of course. We're here, right? No difficulty. But we like to hear an interviewer only if a junior is arguing for the interviewer, not if a senior. Then we have enough seniors on the. But if you are arguing personally, then we'll give you an opportunity before the 7 judges.
Then we don't hear Mr. Gopal Shankar Narayan also.
Not who are really ready for argument.
Well, the juniors who are ready, we'd certainly like to hear you because you must be given an opportunity to appear before the 7 judges.
Well, it's page 12.
By all standards, is tomorrow.
Yes,
So-
we all understand that. We all understand that.
So we take the alternative list now because this matter is well and substantially now underway. So the other members of the bar who want to hear this matter, of course, you're most welcome to sit in the court, but we are not going to take the alternative list today. The alternative list will discharge the board. Yes.
Yes. Page 12 of volume 1.
Yes.
Under the heading minutes, whether the concept of parliamentary oblique legislative privilege as it stands today needs to be further refined, if not altered.
Yes.
D, subheading D towards the bottom of page 12. My lords have got minutes? Subpara 14. The need to further refine the already refined concept of parliamentary oblique legislative privilege may be viewed from 3 standpoints. A, the law of judicial certainty and stare decisis. B, Parliament's views on this matter. C, the unintended consequences which may arise as a result of amending the law by judicial interpretative tools. Now, my lords, on this aspect of judicial certainty, I've culled out the principles and I'll cite 3 or 4 cases, but just the relevant parts. It is a well-settled principle that law should not be unsettled merely on the ground that an alternative view appears to be more reasonable. A judicial precedent cannot be set aside unless A, certain patent aspects of the question had remained unnoticed and the attention of the court on the previous occasion was not drawn to any relevant and material statutory provisions or judicial decisions. B, there was an error in the previous judgment, provided the error had a serious impact on the general administration of law. C, the previous judgment has not been consistently followed in subsequent decisions. That doesn't apply here at all because this has held the field minutes for so long. D, there has arisen a social, constitutional or economic change since the pronouncement of the previous judgment, necessitating a change in judicial stand. Millards, there can be a sea change in thinking, Millards, as in the 377 case, Millards, or in the context in which ADM Jabalpur was overruled. It was a complete change in thinking, Millards. There is no such need in this case, is what I am going to submit, Millards. Since political corruption was a phenomenon very much prevalent from 1967. Ayaram and Gayaram came in 1967, Millards. It's not a recent phenomenon, Millards. Now, Millards, 3 or 4 decisions, Millards. Keshav Mills, para 23. Volume 5, 2 page 87 Millards and para 23 Millards at 294.
Volume 5.
Volume 5, page 287, the judgment starts. Somewhere in the middle, Millards. Somewhere in the middle of para 23 at page 294. Sentence starts, Millards, but different considerations must inevitably arise, because earlier was whether you can set aside a judgment of the High Court. So obviously different considerations apply, but different consideration must inevitably arise where a previous decision of this court has taken a particular view. Justice Padiwal has got it, Millards?
Which paragraph are you?
Para 23, Millards, at page 294. Thanks.
It starts.
In dealing with the
dealing
question.
the
That's right.
As to whether the earlier decisions.
That's right. Millards. That's right.
Correct.
Then, Millards, I'm taking my lord straight to the middle of the paragraph.
Okay.
But different consideration must inevitably arise where a previous decision of this court has taken a particular view as to the construction of a statutory provision, as for instance, section 66(4) of the Act. When it is urged that the view already taken by this court should be reviewed and revised, it may not necessarily be an adequate reason for such review and revision to hold that though the earlier view is a reasonably possible view, the alternative view which is pressed on the subsequent occasion is more reasonable. In reviewing and revising its earlier decision, this court should ask itself whether, in the interest of the public good or any other valid and compulsive reasons, it is necessary that the earlier decision should be revised. When this court decides questions of law, its decisions are, under Article 141, binding on all courts within the territory of India, and so it must be the constant endeavor and concern of this court to introduce and maintain an element of certainty and continuity in the interpretation of law in the country. Frequent exercise by this court of its power to review its earlier decisions on the ground that the view pressed before it later appears to the court to be more reasonable may incidentally tend to make law uncertain and introduce confusion which must be consistently avoided. That is not to say that if on a subsequent occasion this court is satisfied that its earlier decision was clearly erroneous, it should hesitate to correct the error. But before a previous decision is pronounced to be plainly erroneous, this court must be satisfied with a fair amount of unanimity among its members that a revision of the said view is fully justified. It is not possible or desirable, and in any case, it would be inexpedient to lay down any principles which should govern the approach of the court in dealing with the question of reviewing and revising its earlier decisions. It would always depend upon several relevant considerations. What is the nature of the infirmity or error on which a plea for a review and revision of the earlier view is based? On the earlier occasion, did some patent aspects of the question remain unnoticed? Or was the attention of the court not drawn to any relevant and material statutory provision? Or was any previous decision of this court bearing on the point not noticed? Is the court hearing such plea fairly unanimous that there is such an error in the earlier view? What would be the impact of the error on the general administration of law or on public good? Has the earlier decision been followed on subsequent occasions, either by this court or by the high courts? And would the reversal of the earlier decision lead to public inconvenience, hardship, or mischief? These and other considerations must be carefully borne in mind whenever this court is called upon to exercise its jurisdiction to review and revise its earlier decisions. These considerations become still more significant when the earlier decisions happen to be a unanimous decision of a bench of 5 learned judges of this court. Of course, this particular decision is not a unanimous decision. Then,
But Mr. Ramchandran, in your formulation in para 15 of your written submission,
Lordship, please, Manoj.
you say a judicial precedent cannot be set aside unless, and
Yes.
then you sort of break up all the questions which are raised by Chief Justice Gajendra Gadkar into A, B, C, and D.
Lordship, please.
Now, what the judgment in Keshav Mill lays down are illustrative
Lordship.
of when a review can take place or revision can take place, as they call it. They're not exhaustive.
No, they say so much. That line, I read out that line which says it's not possible to give a complete. Yes, Manoj.
And above all, they emphasize the aspect of public good.
Lordship,
What
please,
is
Manoj.
it for the polity.
I bow to that, Manoj. And I am going to submit, when I come to Narasimha Rao's judgment, that this court was the majority itself was very conscious of this concept, Millets, of public good. And that's why, in spite of our sense of indignation, as the expression used, it is not that the court was oblivious of that. Rule of law was, after all, Millets, and is always an overarching consideration when this court decides any constitutional issue, Millets. There's nothing which the court lost sight of, but the court weighed and then preferred the view which the court felt the plain language of the constitution warrants.
Right. Apart from Keshav Mills, you want to cite anything?
Yes, Millets, I would cite one more, Millets. The other I've given Millets, Krishan Kumar and Shankar Raju, but I'll just cite Shah Faisal, Millets, because it's more recent. That was, Millets, when the earlier 5-judge bench in the Article 370 case, Millets, a request was made to refer to 7 judges questioning Sampath Prakashan. Lordship, please. So, Millets, that I'll take my lord straight to 2485 at volume 5 is where the judgment starts, and the relevant part is at 2494. Para 17. Para 17 minutes. Can I read minutes? If all my lords have got minutes.
Yes.
This court's jurisprudence has shown that usually the courts do not overrule the established precedents unless there is a social, constitutional, or economic change mandating such a development. The numbers themselves speak of restraint and the value this court attaches to the doctrine of precedent. This court regards the use of precedent as an indispensable bedrock upon which this court renders justice. The use of such precedents, to some extent, creates certainty upon which individuals can rely and conduct their affairs. It creates a basis for the development of the rule of law. As the Chief Justice of the Supreme Court of the United States, John Roberts, observed during his Senate confirmation hearing, it is a jolt to the legal system when you overrule a precedent. Precedent plays an important role in promoting stability and even-handedness. 18 and 19, I'll make a brief reference, minutes. 18 particularly, doctrines of precedents and stare decisis are the core values of our legal system. They form the tools which further the goal of certainty, stability, and continuity in our legal system. Arguably, judges owe a duty to the concept of certainty in law. Therefore, they often justify their holdings by relying upon established tenets of law. When a decision is rendered by this court, it acquires a reliance interest and the society organizes itself based on the present legal order. When substantial judicial time and resources are spent on references, the same should not be made in a casual or cavalier manner. We have crossed that stage because the reference has been made. We are now on whether it should be reconsidered, this particular judgment. I won't read further from here. Now, I've dealt with one from my bullet point note minutes. Now, 2, 3, 4, and 5, I'll be dealing with together when I place minutes, the majority and minority views in the Narasimha Rao case. All these 4 will get covered minutes when I place that. And minutes, before I come back to my written submission minutes, I wish to draw attention to a passage from Blackstone minutes with regard to the origin of this concept of privilege and how that very thought finds reflection in Justice Bharucha's judgment. Let me take my lord straight, minutes, to volume 4, 1481. Just take it out from my submission here. You take it. Yeah, here it is. Yes, yes.
Volume 4.
Volume 4 minutes at 1487. If all my lords have got minutes, I can place the passage straight away. The privileges of Parliament, the lower part minutes, the lower paragraph. The privileges of Parliament are likewise very large and indefinite, which has occasioned an observation that the principal privilege of Parliament consisted in this, that its privileges were not certainly known to anyone but Parliament itself. And therefore, when in 31, Henry VI, the House of Lords propounded a question to the judges touching the privileges of Parliament, the Chief Justice, in the name of his brethren, declared that they ought not to make an answer to that question, for it has not been used aforetime that the judges should in any wise determine the privileges of the High Court of Parliament, for it is so high and mighty in its nature, that it may make law, and that which is law, it may make no law, and the determination and knowledge of that privilege belongs to the Lords of Parliament and not to the justices. Privilege of Parliament was principally established in order to protect its members not only from being molested by their fellow subjects, but also more especially from being oppressed by the power of the crown. It therefore, all the privileges of Parliament were once to be set down and ascertained, and no privilege to be allowed. But what was so defined and determined, it were easy for the executive power to devise some new case, not within the line of privilege, and under pretense thereof to harass any refractory member and violate the freedom of Parliament. Therefore, minutes, the central thought which I wish to emphasize, minutes, based on the historical origin of privilege is criminal law is one aspect of, minutes, the public good, of public policy, but the independence of members of the Parliament from the crown, and in a democracy substitute it with a democratic executive. It is equally an important factor. And that is where I'll place that relevant passage from Justice Barucha's judgment. This one? Yeah. Now, Milord. This one?
Yes, Mr. Ram.
Yes, ma'am. No. Kindly give me a minute, Milord, sir.
Yes.
No, no, I'm on this. Take from the executive. It is not our end. Your Lordship will just give me half a minute more, Milord. That particular line which I wanted to read at this particular point, Milord. But I may start by reading the judgment in the meantime, Milord. Para 133, volume 5, page 808. No, I will come back to that passage, but it's part of the same judgment, so I'll emphasize it. 133 onwards, Milord.
Volume 5.
Of Narasimha Rao, volume 5, Milord. It's no? 136. Para 133 onwards, I'm reading, Milord. Page number 808, Milord. Can I read, Milord?
Yes.
Broadly interpreted, as we think it should be, Article 1052 protects a member of Parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or a vote given by him in Parliament. The charges against the alleged bribe takers is that they were party to a criminal conspiracy and agreed to or entered into an agreement with the alleged bribe givers to defeat the no confidence motion by illegal means, namely to obtain or agree to obtain gratification other than legal remuneration from the alleged bribe givers as a motive or reward for defeating the no confidence motion, and in pursuance thereof, the alleged bribe givers passed on several lakhs of rupees to the alleged bribe takers, which amounts were accepted by them. The stated object of the alleged conspiracy and agreement is to defeat the no confidence motion, and the alleged bribe takers are said to have received monies as a motive or reward for defeating it. The nexus between the alleged conspiracy and bribe and the no confidence motion is explicit. The charge is that the alleged bribe takers received the bribes to secure the defeat of the no confidence motion. While it is true that the charge against them does not refer to the votes that the alleged bribe takers, Ajit Singh excluded, actually cast against the no confidence motion, and that it may be established he hoarded those votes, as the Attorney General argued, we do not think we can ignore the fact that the votes were cast, and if the facts alleged against the bribe takers are true, then they were cast pursuant to the alleged conspiracy and agreement. It must then follow, given the expression in respect of must receive a broad meaning, that the alleged conspiracy and agreement had a nexus and were in respect of those votes, and that the proposed inquiry in the criminal proceedings is in regard to the motivation thereof. It is difficult, but this paragraph is important, Milord, in the context of Blackstone as well. It is difficult to agree with the learned Attorney General that though the words in respect of must receive a broad meaning, the protection under Article 1052 is limited to court proceedings that impugn the speech that is given or the vote that is cast or arises thereout, or that the object of the protection would be fully satisfied thereby. The object of the protection is to enable members to speak their mind in Parliament and vote in the same way, freed of the fear of being made answerable on that account in a court of law. It is not enough that members should be protected against civil action and criminal proceedings, the cause of action of which is their speech or their vote. To enable members to participate fearlessly in parliamentary debates, members need the wider protection of immunity against all civil and criminal proceedings that bear a nexus to their speech or vote. It is for this reason that a member is not liable to any proceedings in any court in respect of anything said or any vote given by him. Article 105 does not say what it would have if the learned Attorney General were right, that a member is not liable for what he has said or how he has voted. It would have then been worded differently. While imputing, this is important, words. I'm linking this to what Blackstone said then, words. While imputing no such motive to the present prosecution, it is not difficult to envisage a member who has made a speech or cast a vote that is not to the liking of the powers that be, being troubled by a prosecution alleging that he has been party to an agreement and conspiracy to achieve a certain result in Parliament, has been paid, achieve a result in Parliament and had been paid a bribe. Therefore, words, a powerful executive, whatever be the ruling party, words, it's a fact of political life in India today, words, that the law is misused. So this is an equally important consideration. If a member is to vote fearlessly, he should be free from the fear of prosecution. And therefore, it is not just, Millards, an immunity from criminal law. Right. Yeah, after I finish this, I'll come there. Para 137.
137.
Yes, sir. We are acutely conscious of the seriousness of the offense that the alleged bribe takers are said to have committed. If true, they bartered a most solemn trust committed to them by those they represented. By reason of the lucre that they received, they enabled a government to survive. But so they are entitled to the protection that the Constitution plainly affords them. Our sense of indignation should not lead us to construe the Constitution narrowly, impairing the guarantee to effective parliamentary participation and debate. So the majority was equally anguished, my lords. This is not an amoral judgment. The majority would have been as shocked as any court would have been, as any conscientious citizen would have been. But the majority said we must read the Constitution as it is written. And there is reason for it. Members need protection. And then, Millards, as far as criminal prosecution is concerned, you can't differentiate between corruption and defamation. If there is protection from criminal prosecution, it has to be in all respects, Millards. As long as it bears a nexus. In Ajit's case, Millards, this Honorable Court sufficiently refined it, Millards, in the recent Kerala Assembly case. If a member commits an act of vandalism Or let's take an extreme case of a physical assault. Then it is obviously not protected because by no standard can it be said to have a nexus. Similarly, that test may perhaps conceivably be applied to a hate speech situation on the floor of the House also, as to whether it had any nexus at all with the role of the member in the performance of his duties. But once that immunity is there, then we can't dissect it and say corruption shocks us, defamation is of a different character, defamation is more political in character. It has to be absolute protection. And therefore, this anguished conclusion of the majority, bearing in mind what weighed with the constitution makers, bearing in mind the historical background of privilege, is not even 25 years later something which would shock the conscience of this court. To repeat, political corruption is a fact of modern political life and perhaps historical and ancient political life also.
Yes.
And this, and I'm going to emphasize when I come back to my written submission, it is not that the constitution gives a complete carte blanche. After all, the privileges of parliament are to be exercised by parliament itself against its members. And we may trust parliament to do so on given occasions. In the early years, in the provisional parliament, and I've given that instance in my written submission, I'll take my lot to that straight away. A member, one Mr. H.G. Mudgal, was expelled by the House for accepting a bribe to ask a question in the House. From 1952 to Rajaram Pal in 2006, it is not that Parliament has not exercised its power. And so the Constitution leaves it to Parliament to take care of aspects of political morality then I would respectfully submit that the court, out of a sense of moral outrage, ought not to proceed further. And that is the error in Justice Agarwal's judgment, and I'm going to place that passage straight away. Justice Agarwal is conscious of the fact that the power to expel is there. But the judgment says that is not a satisfactory solution. That's the fundamental error, and I say this with great respect, that it is not for the court to find perfect solutions to all moral dilemmas, political problems, political conundrums.
But
The
Mr.
Constitution makes
Mr. Ramchandran, if you really interpret 105(2), the Justice Bharucha rejected the submission of the Attorney General based on the words in respect of. Let's look at 1052. What does it say?
yes, let's go.
No member of parliament shall be liable
To any proceedings
to any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof. So what this really means is that a member of parliament, it says, shall be liable to any proceedings. Shall be liable to means shall be answerable to. or shall be held to account in any court. So once a member of parliament has either cast a vote or has spoken, they will not be answerable in any court of law in any proceeding for the vote which they have cast or the speech which they have made. That's all. And that dovetails with clause 1. Clause 1 begins by saying there shall be freedom of speech in parliament. And then 2 says that freedom of speech in parliament is protected by saying you will not be held to account in a court for a speech which you made. No court can say that, well, why did you make this speech? Or you're answerable to us as a judicial institution in respect of a speech which you made or a vote which you cast. That's the purpose. This does not really seek to implicate other aspects, such as an aspect of criminality. Now, some aspects of political morality are dealt with by the Constitution itself, in the 10th schedule, for instance.
Lordship, please.
Okay,
Which
so
came later? Which came later?
Which came much later. But for instance, the 10th schedule will deal with certain aspects of political morality, namely crossing of floors, casting, acting against the whip, or a defection from the political party. But to read the words in respect of have to be construed appropriately. You're right. Normally, in respect of is not treated as a word of limitation. In respect of is always interpreted in a very broad perspective. In relation to, in respect of. But what is in respect of what? In respect of anything said or any vote given. Will this go beyond a criminal consideration underlying the speech or the vote? Of course, there is a possible view. I mean, you can't, that's why, that's why that judgment is there. Obviously, too, the majority has taken that view and we respect that view. What seems to have weighed with the majority is that if you cannot be responsible in respect of a vote given or a speech made to any court in a proceeding, then the underlying motive for the casting of the vote or the speech, whether it is criminal or otherwise, equally immune from court proceedings.
Lordship, please.
And the question is whether you therefore stretch that in respect of to cover an underlying motive or an underlying consideration being criminal as also being immune, or whether does it stop with the vote cast or the speech which is given, and does it really also extend to a possible criminal misdemeanor in the casting of the vote or the making of the speech?
Just a respectful refinement of what my Lord the Chief Justice has put to me. Straight away here. Show it here. Okay, should. My Lord was.
Yes, I mean, this is the things. I mean, one question is, the way you read sub-article 2 is perhaps is in 2 parts. The first part relates to the vote given by him in the parliament. Anything said or vote given. The later portion which comes after end, after the comma, talks about liability with respect to publication by or under the authority of either House of the Parliament of any report, paper, vote, or proceedings. This later portion talks about the liability with respect to publication, etc. The first part talks about the vote as well as what is said. There is a distinction there.
Sorry to interrupt, also member of parliament versus person. First part is member of parliament, second part is person.
No person shall be.
Person. So therefore, there is a clear distinction there. So whether with the expression in respect of attached to the first part is a question, perhaps that just came to my mind.
Lordship, please.
That is one thing.
Lordship, please.
Does it attach to a pristine situation where a member of a parliament says or votes in a parliament? This has to be read in consonance with the first sub-article 1. Maybe there is perhaps a distinction there because, as they say, publication also,
Yes, ma'am.
and what is published with respect to the proceedings of the House also attaches some amount of immunity. That is what is said.
So the Lok Sabha debates, the Rajya Sabha debates.
There could be something, yes, words.
And that will also attach to a staff of the legislature. The Secretary General of the Lok Sabha
Yes, words. The printer and publisher also.
who will publish a report of the text of the proceedings in the parliament would be equally immune because no person shall be liable in respect of the publication.
Therefore, the use of the word person,
Person.
because they are
Much
expanded
broader.
beyond the member concerned.
There's a long English parliament.
Private
Right.
publication.
That's by or under the authority. Something which is an authorized publication of parliament.
So, which is that expression which connects, so to say, as the later part uses the expression in respect of, so far as the first part is concerned?
Yes, words.
That's the question. That's a question.
Lordship, please.
But otherwise, the other principle that the concept, the activity of corruption, which occurs outside the house, has got nothing to do with what is said and the vote which is being made in the parliament. That's the first part of it. But what, according to you, controls that?
Yes, words.
The first part.
I'll read the sentence again. I'll read the clause again. No member of parliament
My question was slightly different.
Lordship, please. No?
So that consequence of the speech made, consequence on the publication made. These are the only two conditions.
Lordship, please.
Anything happen prior. No, not
That is where
not
I'm,
authorized.
that is where in respect of comes for the,
I'll give you one more. Suppose a bribe has been taken by a member of the legislature for casting a vote in a particular manner, for making a speech. A court cannot therefore say that please invalidate this vote because it was motivated by a bribe. Suppose a person is convicted for the offense of bribery. Can a court say that therefore that vote should be excluded in computing the parliamentary majority? Suppose 20 members of the legislature are proved to have accepted a bribe. That vote is still a valid vote,
Lordship,
cast in favor of or against the motion.
Contextualized. Clearly, it is contextualized in the first part as well as second part when they use that in respect of a vote and what is said and in respect of what is published.
Lordship, please.
Both are very clearly contextualized.
Lordship, please. And bullets, in my respectful submission.
You can't say impugn a resolution passing a legislation or passing the budget on the ground that any of the votes which were cast
To pass the
were
finance.
vitiated by a criminal wrongdoing.
If that be so, if I may.
But that immunity which attaches to the vote which is cast does not attach to the crime which takes place independent of the casting of the vote or the rendering of the speech.
my respectful submission is, if the crime, the anterior crime, so let us assume minutes, and that is a matter of law minutes, there can be no two views about
Let me
it, that
put
the
it-
offense.
Let me put your argument at its best, at the highest.
Lordship, please.
That the anterior crime of accepting a bribe for casting a vote or making a speech is integrally related
Lordship,
to
please.
the casting of the vote or the making of the speech.
That
the
is my
point.
argument, minutes, and that's
And
my,
once both are integrally related, according to you, the immunity must attach to both.
in respect of,
That's the submission
from
there.
Justice Narasimha's
That's the
question
heart of
also,
your
is
The reason of highlighting what you have said of in the previous quotation of Blackstone is as it becomes necessary because of the reason that the executive
Lordship,
perhaps
please.
has a control over the members through some manner or the other. So therefore, the need for an immunity to
Grateful,
extend even to that.
grateful.
That's your argument.
I'm grateful. And apropos,
Yeah,
the observation,
We'll just elaborate what chief is saying is this. In a case where, let us assume there's a bribery, voting take place. Then on the question of validity of the vote, a decision is made within the parliament, that cannot be questioned.
no, it cannot. That
To that
undoubtedly
extent,
can be.
To that extent, there is a casual connection,
Lordship, please.
notwithstanding that. But other things, they stand apart. The criminality stands apart. That has got nothing to do with the parliament.
But that is where my argument, that in respect of,
To that extent, the parliament can, the house can go into whether bribe is there or not, whether vote is there or not. To that extent, it can go into. To either validate or invalidate the vote, it can go into.
Lordship, please, minutes, but.
Now, in PV Narasimha Rao itself, the no confidence motion was defeated, right?
Yes, ma'am.
The court couldn't have said that the no confidence motion has to be now, you have to be now reviewed. And we will therefore now see whether the new no confidence vote was passed or otherwise by excluding these votes of persons who had improperly voted in favor
No, it's-
or against the
There
motion.
are two things, Mr. Ramchandran, that not voting is different and voting consequences are different is one aspect of the matter. Another aspect of the matter is the scope and extent of the immunity.
Yes,
That we need to balance the constitutional intendment of to what extent the constitution intended that the immunity must be extended in the context of speech as well as the vote.
Lordship, please,
How
minutes.
deeper it is depending on what kind of a mischief could happen with the executive intervention. So that's a matter of interest.
Lordship, please.
Yes,
And
to just expand this, what we are saying, it can at best be restricted to the business which the parliament expected to transact. Nothing more, as Manala said, let us take some murder takes place. Now, can we say that parliamentary privilege,
no,
they're trying to take
Yes.
a very larger proportion, then nothing can be done. Supposing some decision is taken, it can be questioned.
it can be, minutes.
So it can be only restricted to the freedom of speech and expression.
No, there always has to be a nexus with an MP or MLA's work or duty as an MP or MLA, minutes. And this is without minutes. I'm not going to my later submission that voting for Rajya Sabha also, not just legislative voting, is also part of the work of an MLA, but it has to be connected with that. And therefore, apropos the observation of the learned Chief Justice as to whether in respect of can be stretched, that was my Lord the Chief Justice's observation. There, my respectful submission is, it is not a question of stretching. The question is, can in respect of be restricted? Can in respect of be restricted? We are not stretching. The language is plain and unambiguous because there is a nexus, there is a causal connection. Then can it be restricted or whittled down? Because it is a crime of a particular nature, which is morally abhorrent. My respectful answer on the plain language of the Constitution is no, it can't be whittled down. We are not expanding in respect of, we are unjustifiably restricting in respect of which ought not, my lords, to be done. Can I, my lords, take my lords to Justice Agarwal's judgment, just a couple of paragraphs, my lords. Paras 45 and 47, volume 5, page 751.
Para 47.
Para 45 first, my lords.
Yes.
Page 751, volume 5, if all my lords have got bills. It is no doubt true that a member who is found to have accepted bribe in connection with the business of Parliament can be punished by House for contempt. But that is not a satisfactory solution. This is where, my lords, value judgment, moral judgment, etc. come in, my lords. And this is where the court has fallen into error. The minority has fallen into error. It is with respect not for the court to find a solution to what seems to be illogical, let's put it even more strongly, unfair in the Constitution. No, it is there in the Constitution. It is part of the original Constitution. And therefore, that exemption, that exception, that immunity is as much a part of the pillar of the Constitution, and therefore not in the basic structure kind of test, but that is also part of the Constitution. That's part of the constitutional architecture. Then, minutes. Paras 46 and 47. The expression in respect of has to be construed in this perspective. The cases cited by Sri Rao do show that this expression has been construed as having a wider meaning to convey some connection or relation in between the two subject matters to which the word refers. Words refer. But as laid down by this court in State of Madras versus Swastik Tobacco Factory, the expression has received a wide interpretation, having regard to the object of the provisions and the setting in which the said words appeared. The expression in respect of an Article 1052 has therefore to be construed keeping in view the object of 1052 and the setting in which the expression appears in that provision. As mentioned earlier, the object of the immunity conferred under Article 1052 is to ensure the independence of the individual legislators. Such independence is necessary for healthy functioning of the system of parliamentary democracy adopted in the Constitution. Parliamentary democracy is a part of the basic structure of the Constitution. An interpretation of the provisions of Article 1052, which would enable a member of Parliament to claim immunity from prosecution in a criminal court for an offence of bribery in connection with anything said by him or a vote given by him in Parliament or any committee thereof, and thereby place such members above the law, would not only be repugnant to a healthy functioning of parliamentary democracy, but would also be subversive of the rule of law, which is an essential part of the basic structure of the Constitution. It is settled law that in interpreting the constitutional provisions, the court should adopt a construction which strengthens the foundational features of the basic structure of the Constitution. No doubt about that, there is no quarrel with that proposition. The expression in respect of precedes the words anything said or any vote given in Article 1052. Apropos Justice Narasimha's question, minutes. The words anything said or any vote given can only mean speech that has already been made or a vote that has already been given. The immunity from liability, therefore, comes into play only if a speech has been made or a vote has been given. the immunity would not be available in a case where a speech has not been made or a vote has not been given. When there is a prior agreement wherein a member of parliament has received an illegal consideration in order to exercise his right to speak or to give his vote in a particular manner on a matter coming up for consideration before the House, there can be two possible situations. There may be an agreement wherein a member accepts illegal gratification and agrees not to speak in parliament or not to give his vote in parliament. The immunity granted under Article 1052 would not be available to such a member, and he would be liable to be prosecuted on the charge of bribery in a criminal court. What would be the position if the agreement is that in lieu of the illegal gratification paid or promised, the member would speak or give his vote in parliament in a particular manner, and he speaks and gives his vote in that manner? As per the wide meaning suggested by Shri Rao for the expression in respect of, the immunity for prosecution would be available to the member who has received illegal gratification under such agreement for speaking or giving his vote, and who has spoken or given his vote in parliament as per the said agreement, because such acceptance of illegal gratification has a nexus or connection with such speaking or giving of vote by that member. If the construction placed by Shri Rao on the expression in respect of is adopted, a member would be liable to be prosecuted on a charge of bribery. If he accepts the bribe for not speaking or for not giving his vote on a matter under consideration before the House, but he would enjoy immunity from prosecution for such a charge if he accepts bribe for speaking or giving his vote in parliament in a particular manner, and he speaks or gives his vote in parliament in that manner. It is difficult to conceive that the framers of the Constitution intended to make such a distinction in the matter of grant of immunity between a member of parliament who receives bribe for speaking or giving his vote in parliament in a particular manner and speaks or gives his vote in that manner, and a member of parliament who receives bribe for not speaking or not giving his vote on a particular matter coming up before the House and does not speak or give his vote as per the agreement as to confer an immunity from prosecution on charge of bribery or on the charge of bribery on the former, but denying such immunity to the latter. Such an anomalous situation would be avoided if the words in respect of in Article 1052 are construed to mean arising out of. In the expression, if the expression in respect of is thus construed, the immunity conferred under Article 105(2) would be confined to liability that arises out of or is attributable to member to something that has been said or a vote that has been given by a member in parliament or a committee thereof. The immunity would be available only if the speech has been made, or the vote that has been given is an essential and integral part of the cause of action for the proceedings giving rise to the liability. The immunity would not be available to give protection against liability for an act that precedes the making of the speech or giving the vote by a member in parliament, even though it may have a connection with the speech. So, in respect of is here, but that is sought to be whittled down by saying, no, it must be in respect of.
Of course, this distinction which Justice Agarwal makes,
Yes, Minister.
there is in that sense an agreement with the majority also, because that is how how Ajit Singh was held not to be immune by the majority as well. So this anomaly, so-called, I mean, the anomaly is what we have used in that the third formulation which we made in the referral order. There seems to be an agreement even with the majority,
Lordship, please.
because
I think he's citing it, he's citing it as an extreme example to show the anomaly which would arise if
Right.
the other construction is adopted. Actually.
That's right.
He's citing it as an.
And it was actually borne out by what the majority did ultimately, by holding that Mr. Ajit Singh is not immune.
This is actually proved by the result which flows from the majority.
The mistake, the error with respect here is this, that the compendious expression in respect of is sought by this interpretation to say arising from or arising out of to something posterior, and eliminate anything happening anterior. But in respect of is a wide expression which comprehends anything anterior, anything contemporaneous, and anything posterior. There is no justification whatsoever to whittle down I would go so far as to say, be doing violence to language if we were to read in respect of in this manner. And this reading flows only from a sense of moral outrage and with a view to devising what the court feels is a satisfactory solution, because what obtains today under the constitutional scheme, according to the minority, is not a good enough solution. That's what that. Come back one more. Come back.
Yes.
Yes, please. Can I now take my lords further to my note, volume 1, page 14. After this, no, after the concept of ministry further to Parliament's view on the matter. 3 years back, look at page 14 of my written submission, volume 1. There was a recent case, minutes, concerning the Delhi Assembly and some social media, minutes. Para 18, page 14, volume 1.
Yes.
Interestingly, this honorable court, the recent case of Ajit Mohan versus Legislative Assembly, National Capital Territory of Delhi, did observe that there were divergent views among constitutional experts on whether full play must be given to the powers, privileges, and immunities of legislative bodies as originally defined in the Constitution, or is to be restricted. However, despite the divergence of views, this honorable court declined to express or impose its views on the matter, and justifiably so, as held by this honorable court. Such opinion would have to be debated before Parliament or legislature of the state to come to a conclusion one way or the other. It is not even a subject matter where it could be said that any one opinion must prevail, or a nudge must be given by this court, or a recommendation must be made for consideration by the legislative body. The court has left it, minutes, to the legislature. Considering, minutes, we assume the historical background, the high constitutional status which privileges themselves have occupied in constitutions all over the world. Then, minutes, page 15. What has Parliament felt, minutes? Because after all, the criticism has been voiced over the years, minutes. And this is always a vexed issue. Parliamentary Standing Committee reports, the relevance of which was recognized by this honorable court in Kalpana Mehta, are documents that reflect parliamentary oversight. The 48th report of this committee on the Lokpal bill was tabled before both houses of parliament on 9/12/2011. Section 17 of the Lokpal. Section 17 of the Lokpal bill, which related to the jurisdiction of the Lokpal, contained a subsection 2, which prevented the Lokpal from inquiring into any matter connected with the allegations of corruption against any member of either house of parliament in respect of anything said or a vote given by him in parliament or any committee thereof covered under the provisions contained in clause 2 of article 105 of the Constitution. A perusal of the 48th committee report indicates that the committee had indeed extensively discussed the need to omit section 17(2) from the bill so that the Lokpal could indeed inquire into allegations of corruption against MPs. In this context, my lords, of vote given, and the following was the outcome of the said discussion. The committee itself observed that Article 105 did not provide MPs immunity or protection from disciplinary proceedings or sanctions initiated and conducted by Parliament itself. A reference was in fact made to this Honorable Court's verdict in the Rajya Rampal matter. B. Vote, conduct, or speech within the House was intended to promote independent thought and action without fetters within Parliament. The immunity for vote, speech, or conduct within the Houses of Parliament does not in any manner leave culpable MPs blameless or free from sanction. In fact, they are liable to and have in the recent past suffered severe parliamentary punishment, including expulsion from the Houses of Parliament for alleged taking of bribes amounting to as little as rupees 10,000 for asking questions on the floor of the House. Certain oft-cited instances of expulsion of MPs and MLAs for alleged breach of parliamentary and legislative privileges are as follows. A, my lords, I have given Mr. A.J. Mudgal's case. Then, minutes. B, minutes. Mr. Y.R. Meghawale was expelled by the Madhya Pradesh Assembly for assaulting the Deputy Speaker of the House. That expulsion was affirmed. C, Mr. Subramaniam Swamy was expelled from the Rajya Sabha in the context of the events of the emergency, minutes. D, Mrs. Indira Gandhi was expelled, again in the aftermath, minutes, of that very period. Then, minutes, Rajya Rampal. So there are instances. And now, minutes, I come to the next part of the submission, minutes, the unintended consequences of further refining the law.
Yes.
As stated, para 22 minutes. Earlier herein, the purpose of the immunity conferred under Articles 1052 and 194(2) was never to create a class of super citizens, but to insulate MPs and MLAs from the might of the executive. Can I just pause here a minute? Super citizen is a concept which was very much present before the court in Narasimha Rao also, because when you're talking of privilege, the analogy which comes immediately to mind is super citizen, but all constitutional immunities, immunities to governors, immunities to the president, in that sense, because they are a class apart, they are treated differently. Was never to create a class of super citizens, but to insulate MPs and MLAs from the might of the executive. Votes given and speeches made in the legislature usually relate to matters proposed by the party in power, and every such party would have a natural desire to eliminate as much opposition as possible, or at the very least cause a sense of fear among opposing legislators. The parliamentary privilege and immunity conferred upon MPs, MLAs, if further whittled down, would only enhance the prospect of abuse of the law by political parties in power. The following hypothetical, yet very probable examples seek to illustrate this submission, assuming that this Honorable Court declares criminal offences by legislators being unprotected by Articles 105, 194(2), even if they relate to votes made or speeches given in Parliament or legislature. First instance we are given minutes is a case of bribery. A political party X enjoys a very thin majority of 7 seats in a legislative assembly, 5 of which are filled by independent MLAs. The opposition parties form an alliance, and this alliance declares its intent to introduce a no confidence motion following the unearthing of a scam. Given the sensitivity of the issue, the speaker is constrained to grant leave for given the sensitivity of this issue, the Speaker is constrained to grant leave for discussion and voting on the motion. During the voting, 3 out of the 5 independent MLAs vote in favor of the no confidence motion, despite which X barely manages to prove its majority on the floor. Embarrassed by the negative votes of the said 3 independent MLAs, the leader of X lodges frivolous FIRs against them, alleging that they had voted after having agreed to take bribes from the opposition party. The MLAs are consequently arrested, and by the time they are able to procure bail for themselves, they miss out on debates or other important bills which were laid before the House during their absence. But if the court is to take cognizance of reality, as the court does, Millards, always, if political corruption is a fact of life, misuse of the law is equally a fact of life. And this court has often come to the protection of either ordinary citizens or politicians who have suffered unjust prosecution, intimidation at the hands of agencies of different state governments, irrespective of their political hue.
Therefore, should we grant, therefore, immunity to political corruption on the apprehension of a misuse of law?
No, with respect, Millards,
Because
I'm
an apprehended misuse of law is always amenable to protection within the court.
no, my submission is slightly different, Millards. My submission is that since this apprehension of misuse has been at the root of the very grant of privilege and immunity from historical times, it's not that the court is today giving some fresh chit or blanket of immunity. The fact of misuse of persecution by the powers that be is a historical fact of life, whether by powerful monarchs or by powerful executives or even by weak executives in order to survive. Therefore, the court is only being asked to continue what has stood the test of time.
Yes.
Then, Millards, I give another example of a hate speech. I don't need to read it out, Millards. There can be myriad examples, Millards.
Yes.
Then, Millards, kindly come to para 25 at page 20. Okay, before that, Millards, para 24. Indeed, it does not require much effort to think of other hypothetical examples of adverse consequences of truncating the already truncated ambit of parliamentary public legislative privileges. While these examples are hypothetical, no doubt, what is not hypothetical is the fact that legislators would be extremely cautious, if not wary, to make statements or give votes against the ruling party in the event the immunity conferred by 1052 and 194(2) is chiseled even beyond its present form, exposing legislators to prospects of criminal proceedings for votes made or speeches given in the legislature merely to equate legislators to common citizens of the country would only result in them performing their legislative duties with fear and fetters as against without fears and fetters, which was the original intent of legislative privilege in the first place. And Millards, if the concept of chilling effect, which your lordships have applied in the context of freedom of speech to ordinary citizens, the concept of chilling effect, Millards, must equally apply in a context like this, Millards. 10 minutes, para 25, under the heading minutes, addressing the paradox within inverted commas in the PV Narasimha Rao judgment. One of the criticisms of the PV Narasimha Rao judgment is the paradoxical situation that it has resulted in. An alleged bribe taker who had abstained from voting was not granted immunity, while the others were who had actually voted in favor of the bribe giver were granted the said protection. While this paradox may on the face of it sound ironic based on seemingly unintelligible differentia between persons of the same class, one does not need to address the following concerns. One does need to address the following concerns before overruling the ratio of PV Narasimha Rao on this ground. Firstly, A, this paradox was a result of the reading of the very text of Article 1052, which confers immunity for a vote made or a speech given by a legislator. A vote not made or a speech not given would, even by the principle of expressio unius, stand excluded from the purview of Article 1052. Secondly, a constitutional principle resulting in a paradox does not necessarily mean that such a paradox is not constitutionally permissible. The paradox in the instant case merely results in limiting the scope of immunity conferred under Article 1052. As observed by this Honorable Court in Anuradha Basin, albeit in the context of a constitutional right as against a constitutional privilege, such a limitation is certainly permissible as there is no other alternative measure that may similarly achieve the mischief that Article 1052 seeks to address, that is, insulating legislators from being oppressed by the power of the crown. Paradoxical instances are not unknown to constitutional law in any case. The very fact the right to vote is not a fundamental right, even though democracy is part of the basic structure of the Constitution, is in itself the hallmark of a constitutional paradox. Para 27. It is submitted that the majority view in PV Narasimha Rao was aware of this dichotomous result, despite which it laid down the law that it did. The reason for this is certainly not far-fetched. Setting aside a constitutional privilege merely to appeal to what seems logical, inverted commas, would indeed be antithetical to constitutional principles, particularly when setting aside the said privilege may lead to catastrophic consequences in the democratic process of the country. I have minutes covered 2 to 5
Yes.
of my bullet points in my submission so far.
Yes.
Now, what remains for me is only to refute the argument of the CBI that voting in the Rajya Sabha election is not the sort of vote contemplated under 105 2 or 194. I'm sorry, Mills. In my zeal to stick to time,
Yes.
though there is still time, Mills, I omitted to point out two things, Mills, before I come to this last part, Mills. Pages 8 and 9
Of the same submission.
of the same submission, Mills. Without reading in detail, I'll just draw the court's attention. 11 I'll read out, 12 I won't read out, Mills. The recent Kerala Assembly case, Mills,
Yes.
where the judgment was authored by my Lord the Chief Justice, Mills.
That was my judgment, right?
Yes,
Indian,
perfect.
where they threw furniture at each other in the Kerala.
In Parliament, Mills,
Caused a damage of 2,22,000. But see, I mean, constitutional principle emerges on seemingly small cases.
here there was throwing millions of objects. In Central Parliament, Millards, a member of Parliament brought a spray gun, Millards, and sprayed pepper, Millards. Parliament, Millards.
Bifurcation of the state.
In the context of bifurcation of this is to the leading industrialist of the state, Millards.
Yes.
Page 8, Millards. Yes, I refer to Ajit, Millards. And I just want to read out from the summary of the principles which your lordships have culled out from Narasimha Rao, Millards. A, immunity was granted to the legislators in the PV Narasimha Rao case since the connection between the alleged conspiracy, the bribe, and the no confidence motion was explicit. B, given the principles of constitutional supremacy in India, this court does have the power and authority to determine if a particular case falls within the ambit of Articles 194(2) and 1052. C, the purpose of bestowing privileges and immunities to elected members of the legislature is to enable them to perform their functions without hindrance, fear, or favor. D, the first limb of Article 194(2), which provides absolute immunity to members of the Legislative Assembly, is a manifestation of the freedom provided in Article 194(1). Then, para 12, courts in the UK and Canada have, post the Narasimha Rao judgment, followed a similar approach when confronted with issues pertaining to parliamentary public legislative privileges. A necessity test has been uniformly applied to ascertain whether the immunity sought to be invoked was necessarily connected with legislative functions. Then, Millards, given instances of all those cases of different jurisdictions, I won't read, Millards. Yeah. Which one? And there's only one expression, Millards, which I want to draw attention to because I've plagiarized that expression, Millards, in my submission. So I just read that, Millards. Page 10, bottom. Interestingly, two learned judges, while giving a minority, held that parliamentary privilege was not an exception to the rule of law, rather a distinct pillar of the constitutional architecture. That is what, Millards, I have plagiarized, Millards, in para 2 of my bullet points. Millards. Now, Millards, finally, whether a Rajya Sabha election is different in character from voting on a bill or voting on a motion of no confidence, or voting in a committee of parliament.
This could be on merits. Would it really arise on
No,
this reference?
it is necessary Millards, for this reason.
Actually, that was because the learned attorney raised
That's
it.
right.
Would you like to then just defer it with the attorney doesn't raise it? We don't have to.
In any case, this is answered by a separate five-judge bench in Kuldeep.
No,
Nayyar's
I'm dealing with Kuldeep Nayyar.
So
because-
therefore, I mean, if the correctness of that view is not before your, I'm just flagging it for your lordship's consideration.
No, in fact, I am dealing with Kuldeep Nayyar here.
Mr. Ramson, you can summarize that in 10 minutes. You've really held to time, so I'm sure we can give you those 10 minutes to look at this. This is the last point you're making.
I had said beyond lunch Millards, but then
Very fair, actually. And you can wrap up in 10 minutes. We'll
I will,
look at
I
it
will.
and then see whether to go into this later.
Lordship, please note. So I'll just give the reference from my written submission and then without reading Millards, I'll make the argument. Just give me the page from my written submission. Page 22 onwards, Millards.
Let's read that and see how you've formulated it.
Yes, Millards. Page 22, F. Meeting the respondent's case, whether the present case falls within the ambit of Article 194(2). And before that, Millards, I just want to draw attention to Article 80 of the Constitution, Millards. Dealing with Millards, the Council of States, the Rajya Sabha. 84, subclause 4. The representatives of each state in the Council of States shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. Therefore, voting in the Rajya Sabha is one of the duties of an MLA enjoined by the Constitution, not by the Representation of People Act. And so the argument is going to be, where is the scope for saying that this voting is not that voting? Whether it's on the floor of the house or whether it's in the adjacent lobby. And that is why the distinction which I drew while reading the language of 105 and 194 also. Legislature is used separately, House of Legislature is used separately for authorizing publication. But otherwise, legislature is a compendious term. Legislature is something which is in permanent existence as an organ of the state, just as the judiciary is in existence and the executive is in existence. So therefore, legislature doesn't mean house of the legislature. So if in his capacity as a member of a legislature, he is constitutionally enjoined to vote, then he has all the protection of Articles 105 or 194. And Millards, at page 23 Millards,
Yes.
first part with para 30 and 31, para 30, we deal with the sheer logistics of voting. It is in a lobby. In fact, this has also been, this particular vote, and we have given Millards the report of the returning officer, it is in a lobby of the state legislature. How do you divorce it from the chamber of the legislature, this voting has taken place in the Jharkhand legislature. Factually. And then, minutes, a quick comment, minutes, on the cases which they have cited. One is T.N. Sukul, where the question was whether someone who has been elected to a state assembly but has not yet taken his oath as a legislator, whether he can vote in a Rajya Sabha election. That was the question. And in that context, while holding
Yes.
it was in that context, while holding that his vote was valid, he was entitled to vote, that this court said that voting in the Rajya Sabha is different from voting on a bill as a member of the House, and that Mr. Sukul's vote would be valid. No question of immunity or privilege arose. So contrary to the submission made by the Union of India, the facts of the case are relevant. You can't look at the statement of law in the abstract. It arose in the context of this factual submission.
Yes.
Similarly, Madhukar Jaitley's case, minutes. Facts are not clear from what is reported, minutes. But again, it followed P.N. Shukul in this context. And coming, minutes, to the sheet anchor of both the Attorney General submission and the learned amicus submission, which is Kuldeep Nayyar, so clearly distinguishable on a reading of the mere facts of the case, minutes. Kuldeep Nayyar challenged 2 amendments. One is the domicile requirement, domicile in a particular state before you could stand for the Rajya Sabha from that particular state. So this led to very unusual situations. It's a matter of, it's a historical fact, that a distinguished Prime Minister of this country had to be a resident of Assam to be elected to the Rajya Sabha. This amendment did away with it. First part, this Honorable Court held it to be valid. The second was with regard to the secrecy of ballot in a Rajya Sabha election. That was sought to be done away with, to do away with, or at least mitigate or reduce the evil of corruption and floor crossing, consequent floor quashing in the matter of elections to the Rajya Sabha. So, in the context of the submission, that secrecy of ballot is of the essence of voting. This Honorable Court held, while upholding that amendment, that this is not legislative voting for the Rajya Sabha, and that this amendment is valid, intended to cure a larger evil. Where was the question of immunity or privilege involved in any of these cases, and how are these cases being cited against me to say that 194 immunity does not inure to my benefit? So it's completely distinguishable. But if this is to be read as a ratio of Kuldeep Nayyar, then it doesn't have to be part of the order of reference. I am before a bench of 7 learned judges, and I submit that if this is what Kuldeep Nayyar means, and says, then Kuldeep Nayyar is plainly wrong. But your lordships don't have to go to that extent, because Kuldeep Nayyar was in such an entirely different context.
Yes.
I conclude, Millets, by earnestly appealing to my lords not to interfere with a carefully considered, well-reasoned judgment, a judgment which weighs the pros and cons, a judgment which is not unconscious of morality, but still gives plain effect to the words of the Constitution. No ground whatsoever has been made out for your lordships upsetting that view. I'm grateful for a patient hearing.
Thank you, Mr. Ramchandran. Thank you so much, Mr. Ramchandran.
How he can ask me that I have the locus or not, sir? This court have to say that I have the
These
locus or not.
discussions and parleys at the bar are never made a grievance of before the court, Mr. Counsel. There's some tradition. There's some, exactly as Mr. Shankanayan says, these are privileged.
Sir, he is the second highest officer of the court and he
That's all right.
to maintain the decorum of the court.
All right, that's all right. This is not a subject matter of this reference. Yes.
May it please your lordship.
I didn't want to interrupt in this matter. It is not my dignity to interfere that much. But what was said is to offer a seat for so assisting me.
Sir,
And
that's not the-
One second, sir. One second, sir. Mister, the Attorney General is on his feet. Please observe some dignity of the court. You must observe the dignity of the court. The Attorney General has a right of audience. He is speaking. He is the senior most member of the bar. He's addressing the court. Allow him to say, allow him to speak. Yes.
We just asked him whom are you representing. That's about all. I think we should have asked. You could not have asked that question. I think we are wrong. That's about all.
All right, we'll leave it at that. We will leave it at that now. That's all right. Mister, we'll leave it at that. We are not going to hear you on this. Leave it at that. Yes, Mr. Patwalia.
May it please your lordship. Not actually, in my respectful submission, what is really essential for your lordships to see is what is the object and what is the purpose for which this immunity has been granted under Article 105 of the Constitution. Because according to me and according to the law as I have understood it, after PV Narasimha Rao and even on the international arena, the object is not to give protection to an individual from ordinary criminal laws. The object instead is to protect the integrity of the legislative process by ensuring the independence of the individual legislature. And once that be the object, the view, of course, of Justice Agarwal, according to me, is the correct view. And unless there is participation in a legislative process, there is, in my respectful submission, no question of the immunity kicking in. And therefore, that para which was read, according to me, gives the correct enunciation of law. Now, my lord, rather than reading the object and purpose, stating in my own words, I wish to read it from K. Ajit, a judgment of your lordships. Now, I have cited the relevant paragraphs. My written submissions are in volume 2A. I have cited the relevant paragraphs in para 15 at page 16, it starts, of volume 2A. And I'm just going to read these 3-4 paragraphs, my lord, from here itself. This is, my lord, a judgment rendered by my lords and authored by my lord the Chief Justice, my lord, in 2021. So it actually covers the entire earlier period and also gives a brief background of the historical perspective. I would
to come across it.
Yes.
May I just take your lordships to para 44 first?
Where are you reading?
Page 16, my lord.
Page 16.
Para 15.
Yes.
From the above cases, it is evident that a person committing a criminal offense within the precincts of the House does not hold an absolute privilege. Instead, he would possess a qualified privilege and would receive the immunity only if the action bears nexus to the effective participation of the member in the House. Then, my lord, your lordship traces the entire history of UK development of this law, tracing the history of the privileges and immunities enjoyed by members of the House of Commons. Erskine May makes a doctoral division of the position in the UK into various phases. However, the standout feature which emerges from the privileges and immunities of the members of the House of Commons is the absence of an immunity from application of criminal law. This jurisprudential development began in Sir John Eliot, was developed by Justice Stephen in Bradlaugh and cemented by the UK Supreme Court in Charter. There is a valid rationale for this proposition. Now, this paragraph is important. The purpose of bestowing privileges and immunities to elected members of the legislature is to enable them to perform their functions without hindrance, fear, or favor. This has been emphasized by a 3-judge bench in Lokayukta Justice Ripudaman Dayal. I quoted it separately. I'll just take your lordship there also. The oath of office which members of parliament and of the state legislatures have to subscribe requires them to bear true faith and allegiance to the Constitution of India as by law established, uphold the sovereignty and integrity of India, faithfully discharge the duty upon which they are about to enter. It is to create an environment in which they can perform their functions and discharge their duties freely that the Constitution recognizes privileges, and immunities. This is the purpose. These privileges bear a functional relationship to the discharge of functions of a legislature. They are not a mark of status which make legislatures stand on an unequal pedestal. It is of significance that though Article 19(1)(a) expressly recognizes the right to freedom of speech and expression as inhering in every citizen, both Articles 105(1) and 194(1) emphasize that there shall be freedom of speech in Parliament and in legislature of a state. In a sense, Article 19(1)(a) recognizes an individual right to the freedom of speech and expression is vested in all citizens. Article 105 and 194 speak about freedom of speech in Parliament and state legislatures, and in that context must necessarily encompass the creation of an environment in which free speech can be exercised within their precincts. The recognition that there shall be freedom of speech in Parliament and state legislature underlines the need to ensure the existence of conditions in which elected representatives can perform their duties and functions effectively. These duties and functions are as much a matter of duty and trust as they are of right inhering in the representatives who are chosen for by the people. We miss the wood for the trees if we focus on rights without corresponding duties cast upon elected representatives. Privileges and immunities are not gateways to claim exemption from general law of the land, particularly as in this case, the criminal law which governs the action of every citizen. To claim an exemption from application of criminal law would be to betray the trust which is impressed on character of elected representatives as makers and enactors of the law. The entire foundation, which is the application for withdrawal of 321. Then, my lord, I can leave this one.
We have lunch of
The
lunch.
yes.
Just explain to your learned young junior some of the traditions of the bar and just have a word with him.
Yes.